You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thank you very much for tuning in to the next episode of the Max Planck Lawcast. Now, imagine for today that I don't just talk on the Lawcast, but I also have a musical career, and I've written a hit song called the Lawcast Rap. Now, unbeknownst to me, a colleague of mine has been producing YouTube videos on how to make the perfect espresso. But my colleague has also decided to add the Lawcast Rap to the background of her videos. She thinks it's a great song to brew coffee to. Is it okay that she's using my music? Have I been wronged by this? Should I receive some sort of monetary compensation? Or could we even go so far as to say that my colleague has been unjustly enriched? Well, to break down all these topics and talk us through that today, I'm joined by Val. Now, I normally like to introduce my guests by their full name, but today we're going to make an exception because my French is a little rusty, and Val's told me that even the French have trouble with his name. So I'm joined in the studio by
Valentin Pinel le Dret, but indeed Val is perfectly okay.
Okay, thanks, Val. Well, welcome to the show, and you work at the Max Planck Institute for Comparative and International Private Law in Hamburg, where you're just finishing up your PhD thesis on Unjust Enrichment and the Law of Obligations. Couple of big terms there. Why don't you start walking us through by defining the law of obligations?
So the law of obligation is basically the law that is governing the social interaction. So when we think about law of obligation, we usually spontaneously think about contract and wrong. So contract, it's rather intuitive. It's everything, the agreement you pass with another person in order to do something or not do something. And, we make contract every day. Like when you take the bus, it's a contract with the bus company. When you buy your bread, it's a contract with the bakery shop. And the other pillar of the law of obligation would be wrong. And so wrong is when you cause damage to someone. So that can be something rather straightforward, such as injuring someone. You break his arm or leg or whatever you want to break. And can be also something that is rather complex, like defaming someone's reputation or defrauding the interest of your companies, or, can be a lot of variety.
Okay. That's what we would think of in at least the English or the common law legal system as torts, the wrongs. Okay.
Exactly. And in Europe, continental Europe would be like delicts.
Delicts.
We call that delicts.
Okay. Well, they've run us through the obligation, the law of obligations here. Can you tell us then a little bit more about how the second term, unjust enrichment, slots in?
So unjust enrichment will be the third kind of obligation. So like many lawyers say that they are like contract wrong and unjust enrichment. But the thing is, when you talk about contract on wrong, you can immediately think about something precise. You can see the contract passing with the bus company or the bakery shop, or the wrong, you can see the damage you're causing to someone. Mm-hmm. But when I say, give me an example of unjust enrichment, it's a bit blurry, you don't know what would be a case of unjust enrichment. And so the way lawyers are conceptualizing unjust enrichment is by going through a court case. Like they say, there is a court case of unjust enrichment. And that court case would be when someone mistakenly pays something to someone. Okay. And so the example would be you have suffered a damage, and the damage was 1,000 euros. The guy behind the desk in the insurance company, I don't know, had a bad day and put one more zero on the figures. And so you end up with 10,000 euros.
Oh, so his bad day turns into your good day.
Exactly. So mistake of the bank in your favor. And so you receive 9,000 euro you were not supposed to receive. That would be a case of unjust enrichment because you have been enriched of 1,000 euro. It's unjust because there were no reason for that to happen. And so all lawyers agree that you have to give it back to the insurance.
I would be obliged then to give that money back.
Exactly. But so that would be the very basic example. The thing that unjust enrichment goes even further and in more complex form. And the example traditionally we give is let's assume that you are moving with your partner into an apartment that is owned by your partner's parents.
Okay.
And so you are willing to be very romantic, and you are saying I have nothing to give but my work. And so you are going to fully renovate the apartment. Mm-hmm. So you put a lot of work in that. You are changing the floors, you are changing the kitchen, everything. And then the apartment is beautiful. So it was worth 100 and now it's 150.
Okay.
And then immediately after you finish your work, your partner dumps you.
Oh.
And the question is, have the parent of your partner been enriched at your expense?
By the work that I've put into the apartment.
Exactly. And do they have a responsibility, liability towards you to give you back the money?
Yes. Okay.
Some people would say you renovated the apartment on your own volition.
That's right. I was madly in love and voluntarily renovated. Okay.
Exactly. And the parents did not ask you anything.
Yes.
So why would they pay something to you?
Mm-hmm.
Another way of looking at the problem is saying, well, okay, it's unfair, but we are only going to give you back the money that is equivalent to all the costs of the renovation. So, the paint you bought for renovating the apartment.
Okay, the goods okay.
Exactly.
Mm-hmm.
And some people would go as far as saying, when you look at the apartment, it was worth 100 and now it's 150. So you should give the difference to what we call the value added. And so they have to pay you 50.
Okay.
And so, but that is a bit more complicated.
Yeah. Okay. Yeah, that's right. So, because obviously the first example, I guess we could all agree, all right, the insurance company's made a mistake, an error there. I'm obliged to pay that money back. Whereas the second example, the service is rendered, obviously far more complex and would clearly depend more on a range of subjective factors, case by case. I guess you've touched on it then there with these subjective factors. What then is the legal debate surrounding the topic of unjust enrichment?
Well, it would be summed by one question is what is justifying the restitution? So the restitution is the remedy we grant for unjust enrichment. So when you have been enriched, you are supposed to give back the enrichment.
Okay.
And so what is justifying you to make restitution? And it's very difficult for lawyers to grasp because, when you cause damage to someone, like let's say you break my iPhone or you break my leg,
mm-hmm.
You can see why you have to pay me something. Like, my iPhone was worth $1,000 and you have to give back that $1,000 because it's the value of the iPhone. And we are going to assess the damage you caused to my leg.
That depends then if you're a star football player or not.
Yeah,
mm-hmm.
Exactly. And so we can easily assess, it's not easy, but we can see why you have to give it back. But then unjust enrichment, if you think about the insurance company case, like they gave you $9,000 by mistake, their mistake. It's not your mistake. You did not defraud anything. You did not do anything
mm-hmm.
wrong. Why would you have to give back that money? The easy answer would be because it's
That's a moral obligation. That's right. Yeah.
It's the right thing to do. But then the thing is that the further you go away from that core case, the less evident it becomes. So like the example I give all the time is the Earl of Aylesbury. We gave the example in 1900. During the Mediana case. And he said, imagine you have a huge dining room and in that room you have 20 chairs. But as it happened, you are only using 15. And since you are very rich because you have a huge dining room, you have a maid and the maid has been using the 20th chair for many years. And you did not know about it. Then one day you realize that she has been using the chair against your will. And the question would be, is it a case of unjust enrichment? Has she been enriched at your expense?
Mm-hmm.
And so some lawyer would say, of course, the chair was your property.
That's right, yeah.
Yeah, she appropriated your property. She has been using your property against your will. She should be liable. But then other people like me would say, I don't know why she should be liable. You did not suffer any damage because so far you have been using 15 chairs. Whether you had it or not was not relevant.
Oh, okay. So there could be a claim. Someone could say, oh, no, it's wear and tear, but then someone could say, well, no, you weren't using it in the first place. So
Exactly. You end up with a lot of cases where you say, should we proceed to restitution? Should we consider that unjust enrichment? But it's a slippery slope. You don't really know where to put the frontier.
Mm-hmm. Sure. Have you got an example maybe of how that slippery slope could work in action other than that case there? Yeah.
Yeah. So we have plenty of examples. So there is a very controversial example, and it's a spy case, if you like, James Bond. Yeah. And so I always been very fond of that.
Sure.
Case.
It gets people listening. Yeah.
So it's called the Blake case. And so Blake was a spy for the MI6, so a British spy. Okay. And as it happened during the Cold War, he was also working for the Soviets. Ooh. And he got, of course, caught one day. And he was put into jail in London and rather dramatic way, but he escaped from jail and he flew to Moscow.
Oh gosh, it is like a 007 novel.
Yes. And they were watching a movie in the prison at the time. So anyway, he flew to Moscow and made a life there. And one day, the publisher of Ian Fleming, so the guy who wrote James Bond, proposed him to write his memoirs. And Blake accepted and published a book, which was called No Other Choice.
Okay.
And you can't find the book anymore. I mean, you can find it somewhere, in the dark web or whatever. But so anyway, so he was promised a huge sum of money for that, and he received about half of it, I think, something like that. And the UK government was really not happy about Blake making profits of his prisons. And so the British government say, I want the other half to be paid to me.
Okay.
Blake should not be entitled to his money. And the question is, how do you justify that? And so at that time, unjust enrichment was not yet a thing in England, but the House of Lords, which was at the time the Supreme Court of the United Kingdom, ruled that indeed the government was entitled to a remedy for the very reason that Blake had made an agreement with the Crown of being a discreet spy.
Okay.
And so
there was a tacit contract or agreement.
Exactly. No, not even tacit.
Right,
he signed something when he joined the MI6. Yeah. But then he breached that contract, therefore he should be held liable for the profit he was about to make. But then there is a problem with all of that. Everybody agrees that the book he wrote was fairly uncontroversial. There was nothing interesting, like no threat to national security. And per se, the UK government did not suffer any damage.
Okay, right. But there was this moral question hanging in the air, though. Should he be allowed to profit from this activity?
Indeed, and you have this prophylactic argument saying, like, if we let Blake making profit out of his treachery, then what? People are going to breach.
Back to the slippery slope, yeah.
Exactly. And so I think it was a mistake to rule that way because... And actually, Blake benefited from Streisand effect because he became famous after that, very famous after that.
Don't go away, because we're going to have plenty more for you after this short break.
Welcome to Max Planck Law, one of the world's largest networks for legal research, based in Germany. Our world-class institutes invite applications for fully funded PhD and postdoc opportunities in almost any area of law. Join a thriving community of over 400 researchers in an international and interdisciplinary environment. Experience the high quality of life that Germany offers while collaborating with colleagues across institutes, working and writing in English. We provide you with unique specialist libraries, excellent workspaces, and support in developing your research and your academic career. Apply today. For more information, visit law.mpg.de.
Welcome back to the Lawcast. Thanks for listening to us today. Let's leave Blake for a moment, and then, because you just give us an example of how the courts decided in England on such a case, but maybe if you could tell us how a court would then rule, perhaps on the Lord and Maid example that you gave us before with the chair.
It's a very interesting case because, so I work on English and French law, and so in England, for sure, there is a remedy. You have a claim in unjust enrichment because they will consider that you wrongfully used someone else's property, therefore you should be liable for whatever use you had of the chair. But when people in England asked me, like, what would the French judge do? I was completely puzzled by that. I said, they will do nothing.
Okay. They're probably puzzled by that response as well.
Yeah, so because I say, from a French perspective, the judge is going to look at the damage. Have you suffered the damage? And in that case, the judge would say, well, you had 20 chair, you only use 15, you only realize it now. Yeah. I mean, there's no damage, so no remedy for you.
Okay. Well, let's return then to my example of the Lawcast rap. It's a different scenario, but would it have the same result?
The case of your app would be a bit different because it's what we call intellectual property, and intellectual property has a statutory regime that is a bit different from all the rest in private law. And so basically we have a lot of stages dealing with those matters, and usually in both sides of the channel, the judge are willing to grant remedies, although they will disagree on the way of assessing the damage you suffered. Like if your rap was not that famous, and I'm sorry for that, but
breaking my heart, Val.
If you were a rather insignificant singer and only your colleague has been using your rap, then the damage is not that problematic. But then if you are Taylor Swift, whatever, then, problematic.
And I guess it probably depends then as well if my colleague was making the videos for profit or simply for fun.
Yeah, exactly. Yeah. Also, and you have all those rules of IP law about fair citation and all stuff. So,
Okay. So in that case, the Lawcast rap wouldn't fall under unjust enrichment because there's already a law dealing with this in intellectual property.
Exactly. And so, then there is this problem of conceptualizing. Is it falling into the unjust enrichment or is it something different? And so the people like me would say let's not make it complicated. It's something different. Some people will say, no, there is a broader law of unjust enrichment. We have to put things into a ground scheme. And but then it's a never-ending story because you can always find something that is relating to unjust enrichment in
sure. Well, then tell us then, how are you going about the research in your PhD? You just mentioned that you're looking at the emergence of unjust enrichment and the way it's dealt with by law in England and France. What kind of perspective are you taking here?
So I want to avoid to have this, like the technical discussion about unjust enrichment or like the theoretical discussion. I want to look at the history of unjust enrichment in both legal systems, because what is very interesting is, and it's also explained why I had such a weird reaction when my English friends asked me about whether there would be a remedy for the chair case.
The chair case, yeah.
Because in France, unjust enrichment is not a thing.
Okay.
If you go to France and ask to a French lawyer, what is your law of unjust enrichment? He will look at you puzzled and say, like, we don't have a law of unjust enrichment in France.
Right.
Yeah. And so we have a lot of institutions that are dealing more or less directly with unjust enrichment, but that they're not conceptualized as part of the law.
It's not a term per se, unjust enrichment.
Exactly. And like people who are very familiar with the subject would say, like, some professors do talk about unjust enrichment, but it's like rather doctrinal discussion. It's not really practical. Like there is no practical implication with that. And then it would say, we have a tiny equity action in unjust enrichment, in French law called unjustified enrichment. Then they will say, like, well, we have that, but we only use that when there is no other solution, and it's very tiny and it's mostly equitable. So like there's not much of a thing. So they will be very puzzled. On the contrary, the English, when you say unjust enrichment, say, oh yeah, talk about it. Like, indeed, it's a thing. It's a very recent thing. It was created in the early 1990s, so I was not even born.
No.
And
I'm not going to comment for myself.
No. But it's very new.
Okay, right.
And then the question is, how come those two systems are so different? And going back to history, it's very interesting and saying why we came about those theories, like what presided to the creation of such systems.
Okay, right. So you're kind of going back in time to then look at where we are at the present then.
Yeah, exactly. And I'm trying to understand like where the motivation behind all of that.
Sure. We're going back in time, obviously talking a reasonable span of time here. What sources were you using, and have the debates on this been digitalized, or are you kind of literally hitting some very dusty books?
Yeah, so I have to deal with very dusty books, and it's quite problematic because whoever worked with like very old books, that it's very dusty, and your eyes are always irritating, and then always go home and like you have a lot of marks on my clothes.
Oh, okay. You're really giving it up for science here. Gosh, sacrificing for the research.
Indeed. And I mean, we do the very dangerous work. But so we have a huge difference in France. The National Library digitalized a lot of very old books. So I don't have to dig that much into the old literature. I don't have to suffer much.
Yes, gotcha.
It's all digitalized. Mm-hmm. And they have a nice software when you can do keyword research.
So I was wondering about these old books whether you could do keyword searches or not, but they've got you covered there.
Yeah. And it worked quite well, although before the 16th century, the font is a bit peculiar, and so the computer doesn't recognize it. Mm-hmm. But there is a problem when you do research on French, and the case law is not digitalized. So you have to go into the old books, and it's very problematic. But the problem is, since unjust enrichment is not a thing in France, what are you looking for?
But what are the keywords you're putting in? Yeah, sure.
Exactly. And so you have clues. You know that he's likely to use that Latin sentence, or he's going to use that concept or that word. And you know that that guy was very interested by that subject.
Wow.
And so there's no way around. So you can put keywords. It's going to make your life a bit easier, but not that much, because you have to look at all the books.
The real detective work.
Yeah. And I mean, the eyes irritation is no joke. Like it's really,
okay.
You dig into the book, your hands end up dirty. And so then you put your, scratch your eyes, and there you go.
Okay.
So fortunately in England, it's a bit different. Like everything is digitalized. You can find everything online. I mean, apart from very weird stuff, but like usually it's not much problem. And also, since unjust enrichment is a thing, legal historians are very interested by it. So they do a lot of historical research. So at least you know where to direct your research.
Okay. So you haven't just had to use primary sources there. You've got secondary sources who can kind of point the way as well.
Exactly. So you are not lost. Like, you know the path. Actually, it's very reassuring because they can tell you where you are off track or not. And so like in French law, you have no way of knowing where you go. Or, I mean, the French usually go back in time, but like back to Roman law. And so you have like a weird gap between Roman law and modern law, and you have a Middle Age that does not exist, and you don't know where is the Middle Age. And so you have to do the Middle Age thing. Okay. And I did it, and it's not funny.
Oh, gosh. Now, you told me before the program that you have been working on this doctoral thesis for quite some time. How many years is it now?
7.
7, all right. What was your hypothesis to begin with?
So when I started my PhD, I can divide my PhD in 3 periods. I was 3 years in France at Sorbonne in Paris, then 1 year in Oxford, and then 3 years in Germany. And for the 3 first year, I was my French time, I was entirely convinced that French law should adopt the English unjust enrichment model.
Okay.
Instead of having a lot of actions on institutions that are more or less directly dealing with unjust enrichment, we should create one general action in unjust enrichment, like the English.
Like the English do, okay.
Okay, so we should do that. And the way of proving that we should do that way is to show that historically unjust enrichment has always been there and that we just need to recognize it officially. And by saying everything merged into one single model. And so so that was my theory, my hypothesis at the beginning.
Okay, that was the hypothesis and the theory behind it. How do you now feel after spending, I guess, 7 years in dusty books?
That I was wrong. It was completely wrong. It took me a lot of time to figure that out. But what I realized is it's always a problem when you do history and what we will call a posteriori histories. When you know the end of the story, you have the tendency of seeing for clues before, saying that we end up there. So it has to be somewhere there from the beginning.
Okay, gotcha,
and so you go back.
You're kind of looking for red flag somewhere along the way.
Exactly, and clues everywhere. So the thing is, you can manage to do it, but then you have to distort a lot of historical materials to have your theory working. And actually, when I arrived in England, I realized there's something wrong with my theory. And I was but what is wrong? And so what you realize is, French law, the reason why unjust enrichment is not a thing in French law is because it was never necessary to be a thing. The French created a model that was working perfectly fine, and it's still working perfectly fine. And the fact that unjust enrichment just presents itself through this very tiny equitable action that I mentioned earlier, well, it's because there is not much to add to the system. The system is working perfectly fine, and there is no institution converging toward a single model. It's not what happened. And actually, the way for me to figure that out was to study English law. Because in English law, they had about this completely different in terms of contents, don't get me wrong, but they had this system of different institutions dealing with the problem more or less directly. And eventually they adopted the unjust enrichment model. But the reason why they had adopted the unjust enrichment model was because some people said we should create that model, and they were academics mostly, and they lobbied for it. And they said it's the model we should adopt, we should do that. And for a long time, the judges were resisting the idea, but eventually they said, why not? And they gave up, and they say, okay, let's go for unjust enrichment.
And was it because they found that there was something missing there that the French didn't find was missing?
So, it's a very controversial subject because from the English perspective, a lot of traditional lawyers, and I say traditional because, and I would include myself in that category, so not as an English lawyer, but they would say everything was working fine. It was a bit bizarre. Okay. But did we need to create that theory? Nothing was really missing. It just was a weird system. It was not the clearest model, but nothing was missing per se. And actually people are now interested into French law, saying look at French law. They are doing fine with the unjust enrichment model.
Yeah.
And so there is not something missing per se, but it's just, a lot of academics got interested into that in the 70s, 80s, and they created a very complex theory on very elaborated theories. And some academics were extremely charismatic, and they trained a lot of judges or soon-to-be judges. And the idea was somewhere there, and eventually the idea received some approbation on the highest level of the courts. And so it's how it worked, basically. But not because it was necessary, just because it happened to be well defended.
There was a push for it then, obviously, as you were saying.
Yeah, definitely a push. And and the thing is it's a stretch to go from one model to the other. It's if someone were to say French law is converging toward the theory of unjust enrichment, that person is saying nonsense. That is not true.
Okay.
It's not converging. It's perfectly possible to move to the unjust enrichment model, saying everybody is going to be liable for every enrichment that he has received at the expense of another. That's perfectly possible, but then you have to get rid of all the institutions that are existing so far and that are working quite well.
Oh, okay. Right. So that would have to be a conscious political judicial decision. Okay.
Yeah, exactly. You need to have that moment, someone's parliament or the judges saying now we are moving toward that model, and that can explain why they want to go to that model, but then it's not going to happen naturally. It's what I not discover because it's established quite well. Don't look at history to justify that. You really need to make a decision on that point.
Okay. I find it quite interesting when you say it's not going to happen naturally. Because all these changes, unjust enrichment won't come naturally to a legal system. Because I guess for me, and maybe this is my shade of the world, because I've grown up in the common law system, I think, well, hey, the law cast rap, for me, it seems entirely natural that, at least at first glance, I've been wronged until I've can be convinced otherwise. What would you say to that?
So I would say that nothing is natural with law. So the way that we look at unjust enrichment is in two circles. You have the core case, like the insurance case, like where they pay by mistake the wrong amount of money. Then you can see why you need a restitution, and because the insurance company suffered a damage, like 9,000 euro damage.
That's right.
Because they paid. And you gain 9,000 euros. You should not have gained that. So that you can see the connection why you should make restitution. But when you start to go a bit further away from that core case, it becomes very, very blurry. Like if you take the apartment thing, if you are a romantic, you would say it was a romantic gesture. And so why would you have to ask for the added value? It's a bit petty. Like,
what would give me the right where have I been wronged?
Exactly. And so then some people will say, yeah, okay, but at least we can give him back all the goods he bought for renovating the apartment. At least that would be like slightly romantic. And then other people say even more, like saying like, no, he enriched the step parents, and like, no, they should like give back the added value. And like, then it's weird. And the example I gave to my student in Paris was what we call the Fourré case. So it's a French case. So it was a man who took care of his parents when they were old. And he took so much care of them that he made a lot of personal sacrifice. And they died eventually. And as they died, when we opened the succession, so in France, succession has to be split equally between children.
Okay.
And he said to his sister, I want more than you because I took care of them. And because I took care of them, they have been enriched at my expense. So they should give me the succession.
You were being enriched, so to say, at my expense, or the sister. No. It's the parents are.
The
parents have been unjustly enriched.
Yeah, because they paid they did not pay anything.
Okay, I can understand for the care that he provided. Okay. Mm-hmm.
And so it's why he's acting against saying the succession should pay something. And the sister said, no, you're not going to receive anything. The succession should be split equally. When I present the case to my student, you can say immediately that the class is divided into two. You have those who say like it's fair. It should be rewarded for his sacrifice. And some people say, well, no, I mean, it's his parents. Like, of course he had to do it. And of course he's not going to ask anything, because what kind of weird society would be? Like, you take care of your parents and you expect to receive more money at the end.
Sure, yeah.
And the court, like the Supreme Court in France, say like, okay, you are entitled to a remedy. You should receive something because they have been indeed unjustly enriched at your expense. And I found that extremely bogus. I don't know why.
Right. Okay. So the court actually sided in this case with the plaintiff.
Yes.
Okay.
Yes, and they use this tiny equitable remedy thing, like I was mentioning earlier. They say like, yeah, but you see, so much sacrifice, and they were mentioning like very old concept of like filial piety and like all.
Oh, okay.
Yeah, a bunch of nonsense.
Also hitting the history books.
Exactly, and so then it's like you should not have been awarded a remedy in that case. And same for your low caste rap. Yeah. But like if it's worth nothing and you lost nothing, and then why should you be entitled to a remedy? And so some people would say
the principle, right? I mean,
hey. Yeah, exactly. And so some people would say it's a principle of it, but then I would prefer to be pragmatic. But it reminds me of this story. Like I had a professor in Oxford who told me like, you can tell how moral a person is when you ask their position on unjust enrichment.
Okay, yeah.
If you're very moral, they would say like, you grant remedy as a principle, you've been like, perhaps no damage, but like it's no, we can't let that enrichment happen. And you have those who do not believe in humanity, or like who are more a bit skeptical, and they say like, no, we only grant you a remedy if you suffer damage. He was making fun of me, but so joke on him because
I can imagine he was saying you're not a very good human, right?
Exactly, but so the thing is, because also he shares the same position than me, I think he would be even more extreme than me.
Okay.
But then what I say is like, well, perhaps I'm the good person in that story, because if I let someone being enriched at my expense when I suffered no damage, I'm just a generous person. That's how I would see it. Okay. And so like, let's not make it complicated, and let's try to keep it small.
Sure. Okay. Right. Okay. So, yeah, I understand. Not to go down that slippery slope. Let's just keep it small.
Yeah,
And
definitely.
keeping it small, that's a good way to jump to my next question for you. You're condensing a lot of legal philosophy and thinking here from two very different legal systems into one thesis. It sounds like a pretty ambitious project. Have you at times felt that you've bitten off more than you can chew?
It's been 7 years I've been lost in my PhD, so definitely. The worst part is that when I started my PhD, my supervisor told me from the first or second year onward, don't be simple, keep it simple.
Oh dear.
And then, all my mentors in Paris, Oxford, and Hamburg told me, keep it simple, be careful, you're going too far, you're going to deal with too much stuff.
Okay.
I did not listen.
You were warned, but you did not listen. Oh man, Val.
I did not listen. I got lost, and voila. It's basically what happened. Is that at one moment I realized that okay, there are a lot of to deal with, and also I realized my shortcoming there. I'm not very good at theoretical discussion. I'm not.
Okay.
So I was like, okay, I don't know what to do. And the anecdote I gave all the time is one day I tried to write a chapter on commutative justice. I'm very, very, very bad at theory. And one of my mentors in Paris, she gave me back the chapter completely read of correction and said, you don't understand anything about theory of law. And I was like, yeah, apparently. So then it's why I try to go back to the basics and do history and stuff I'm good at. And then I was able to make progress. But the worst part is that I'm sure I did not learn the lesson. I would do it again because ego.
Oh dear. Well, look, I'm going to learn the lesson, and I'm going to wrap things up now before we bite off more than we can chew. I think that's a good a point as any. Val, I've heard that you're actually heading off to Melbourne with the Max Planck Law Network. You've got an exchange planned there.
Yep.
Awesome. I'm a Melburnian by birth myself, and all I wanted to say is have a wonderful time there, and don't worry too much about the snakes and spiders. It's probably the infamous bin chicken that is most likely to ruin your day by unjustly enriching itself on your lunch. So have a wonderful time down under, and thanks so much for coming on the show today.
Thank you for having me. Thank you.
All right. Take care, mate. Look after yourself. Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.